Great news out of the state of Ohio. Remember how I taught you that all cases are important, but only some cases are precedential. This is a huge win for the Second Amendment in the state of Ohio, and we're going to talk about the difference between important cases and precedential cases in the context of this major win for the right to keep and bear arms in Ohio State Court when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in the category of top voices of the Second Amendment for a 2025 Gundy's Award, going to be awarded at the end of January. I appreciate all your support in getting me into the top 5. It was very stiff competition this year. There's a lot of great social media influencers and YouTubers out there in the Second Amendment space, and I'm proud that I made it into the final 5 again for the third year in a row. So thank you for your support. All right, folks, so big deal. In the case of the state of Ohio versus Kendall Brown, the mid-level appellate court in Ohio, in a powerful decision by Judge Pierre Bergeron, has just ruled that an individual indicted, subject to indictment, could not be found guilty or could not be convicted or even charged of possession of a firearm simply because he was under an indictment. An indictment, by the way, that ultimately fell by the wayside, an indictment for robbery that fell by the wayside and was no good. Nevertheless, the state decided to continue to charge Mr. Brown for possessing a handgun while under indictment, and I'm happy to report that the Second Amendment was vindicated, and a right to keep and bear arms was also vindicated in this case of Brown, Ohio versus Brown. Now, this is important because this is another example of how the Rahimi case, which Mr. Rahimi himself lost that case, but remember, there's two critical things to understand in Second Amendment litigation in front of the Supreme Court. That is, who wins the case and who loses the case is very important, of course, but it's equally, if not more important, to understand how they lost the case. And remember, when Rahimi himself lost his case under the Second Amendment in the Supreme Court, Mr. Rahimi being subject to a domestic violence restraining order and then possessing a gun, was convicted of that crime and lost the Second Amendment challenge specifically. But I pointed out that Rahimi was really a win for the Second Amendment, even though Mr. Rahimi himself lost. And the reason why the Rahimi case was a win for the Second Amendment is because it really made it clear that the only time you can take away a firearm, you can only take away the right to keep arms for an American, is if they are found to be a violent danger to someone else after there's been some sort of a hearing and a finding by a court that specifically says he's a danger to someone else, a violent danger to someone else. And even in that circumstance, Rahimi, the case stands for the proposition you can only be temporarily disarmed. You can't be disarmed for your entire life. So to understand why this is another great precedent, another brick in the wall in support of the Second Amendment, let's go through the basic facts here of the case. In 2023, a grand jury indicted Mr. Brown on one count of robbery. The court released Mr. Brown on bond with an electronic monitoring unit, ankle monitor, but it did not place any restrictions on his ability to possess a firearm. During a home visit by the EMU, the electronic monitoring unit team, they located a loaded firearm in his apartment. This discovery spawned a new indictment under Ohio law for having a weapon under a disability. The state's robbery case against Mr. Brown eventually collapsed, which led to the dismissal of the robbery charges against him. But since the weapons under a disability, meaning the weapons while you were under indictment, since the weapons under a disability case was still in play, Mr. Brown moved to dismiss his indictment, raising an as-applied challenge to the statute, relying heavily on Bruin. So you see what just happened here. So Mr. Brown is indicted by a grand jury, and as you know the old saying, a grand jury will indict a ham sandwich if a prosecutor asks them to. It's very easy to get an indictment in American life. Grand juries were supposed to actually be a check on the government. They were supposed to be a pro-freedom tool, But in modern American life, unfortunately, grand juries have really become, in my opinion, a rubber stamp to the government's overreaching powers when it comes to criminal law. But the discussion of how grand juries went from being a check on the government at the time of our founding to a rubber stamp in favor of government today is the subject of a separate video. So all you need to understand is Mr. Brown was indicted by a grand jury. That case against him for robbery went away and collapsed. It was no good. Couldn't be proven. Very unclear what happened. No go. But nevertheless, during that time period while he was under indictment for robbery, he was found in possession of a firearm, which violated an Ohio statute. Judge Bergeron said the only 3 states that they could identify that had this law that says if you're under indictment you cannot possess a firearm was Washington State, Hawaii, and Ohio. And Judge Bergeron said this proves that not only are these laws not even long-standing, meaning they don't go back to like the time of the founding, they're not even long-standing and prominent in American life today. There's only 3 of these. They're very much a distinct outlier. These are outlier laws, which is not dispositive, Judge Bergeron pointed out. But Judge Bergeron did go on to say that it was sort of, raised an eyebrow, if you will, as to, are these really laws that are consistent with a long-standing historical tradition of firearms regulation when they're even outliers in modern-day America. So with that said, Judge Bergeron then analyzed the case the proper way. He discussed and described, as we've talked about on this channel repeatedly, the Heller-Bruen methodology of you start with the text of the Second Amendment, and if that's implicated by the conduct alleged to have occurred by the, in this case, criminal defendant, and if the dots are connected up, then the burden shifts to the government to show there's a long-standing historical tradition of firearms regulation that would warrant the upholding of the modern-day gun control law in a way that would still be consistent with the Second Amendment. Here, in this particular case of Ohio versus Brown, Mr. Brown's lawyer said, hey, this is preventing me from keeping and bearing arms because the law says that once I'm under indictment, I can't have a gun. So obviously that implicates the right to keep and to bear. Right to keep means the right to possess. The right to bear means the right to carry in public for self-defense. Obviously, if I can't possess a gun at all, it violates both my right to keep and my right to bear. And basically the state agreed as a matter of text that that modern-day Ohio law that says you cannot possess a firearm while under indictment was implicated the text of the Second Amendment, thereby shifting the burden to the government to show what? A long-standing tradition of firearms regulation. But again, Judge Bergeron, as I noted before, said, hey, this is an outlier law even today. The law in Ohio had only been on the books in Ohio for 50 years. And I'm going to say this is a very well-written opinion by this Judge Bergeron out there in Ohio, where he specifically says, you look at the time of the founding in 1791, when the Second Amendment was effectuated, when it went into effect, to figure out at the time of the founding, what were the laws on the books. And there's no such law like this on the books at the time of the founding. Then, and this is very astute legal work in my opinion, the government tried to say, well, you had all these laws at the time of the founding that says that if you're convicted of a felony, listen carefully, folks, this is a key distinction. If at the time of the founding in 1791, when the Second Amendment and the Bill of Rights was adopted, if you were convicted of a felony, you could be put to death and all sorts of terrible things could go on, including losing all your property, yada, yada, yada. But Judge Bergeron writes very coherently and says, look, that doesn't help you state of Ohio today. Because think about it for a moment. The court says that this law that says that if you're under indictment by a grand jury, you can't possess firearms, is totally different than a scenario where you've been convicted of a felony. How so? Well, just think about it. To be convicted of a felony, Judge Bergeron points out, 2 things have to happen, at least at the time of the founding, even today. One is you have to have a trial in front of a jury. You have a constitutional right to a trial by jury. It's literally in the Bill of Rights. So if you're simply under indictment by a grand jury, it just says you've been charged. There's enough evidence to charge you with a crime. That doesn't mean you did it. That doesn't mean the government can prove it. It just means there's enough evidence to charge you and accuse you of committing the crime to allow the case to move forward. In contrast, to be convicted, you have to be found by a jury after all the evidence, including defense evidence, is put in on the record. You have to be found beyond a reasonable doubt by a jury that you committed the crime. So Judge Bergeron here in this case in Ohio says, look, the indictment statute that we're talking about today doesn't have that jury protection because it just says you've been charged. Whereas to be convicted of a felony at the time of the founding, you had to be convicted by a jury. So that's a key distinction between the laws on the books dealing with disarmament of people convicted of felonies at the time of the founding versus people just charged with a felony today. Moreover, Judge Bergeron points out you have due process considerations and protections. Due process means, of course, you have the right to be heard, that you have a right to be given notification that you've been charged, and you have a right to put on evidence and be heard and cross-examine witnesses and confront witnesses and the like. So Judge Bergeron says, again, at the time of the founding, you had a right to a trial, you had a right to due process, you had a right to cross-examine witnesses, you had a right to confront witnesses, you could testify, all sorts of things occurred for due process protections at the time of the founding. That is, again, dramatically different than simply being indicted and charged with a crime today. Therefore, Judge Bergeron said that the only evidence or historical evidence that the state has come up with that could conceivably sort of justify this was basically laws that presuppose that you were convicted of a crime at the time of founding after a jury heard the case and you had due process and you were convicted by the heightened standard of proof or burden of proof of beyond a reasonable doubt. None of these procedural protections I just described apply to someone simply being indicted by a grand jury, a same kind of grand jury that would indict a ham sandwich if a prosecutor asked them to do so. So in light of this, Judge Bergeron in this opinion said, this historical evidence proffered by Ohio is simply inadequate, insufficient to prove the existence of a long-standing historical set of laws and regulations going back to the 1791 founding of our country and founding of the Second Amendment to justify the modern-day gun control law restriction that says that if you've merely been indicted for a crime, you lose your right to keep and bear arms during that time period. So in light of that, the indictment against Kendall Brown was dismissed by this court, applying Heller, Bruin, and of course, even Rahimi. And what's interesting is the state tried to use Rahimi as a weapon against Kendall Brown to justify the indictment of him having a firearm while under an indictment. And Judge Bergeron was hearing none of this. He was having none of it, pointing out how narrow the Rahimi decision was. Remember, we've talked about this on this channel repeatedly. I even wrote an entire article about this in the Harvard Journal of Law and Public Policy explaining that contrary to what the anti-gunners in the mainstream media want to tell you, the Rahimi case was a terrible blow against the anti-gun movement in America because it narrowed the context, it narrowed the scenarios and situations in which you could be disarmed to you have to have been found to be a violent danger to someone else after a hearing and a finding by a court. And even under those circumstances, you can only be temporarily disarmed, not permanently. So Rahimi has many positive things, in addition to the other language in that case that says that simply being not responsible is not a basis for taking away your right to keep and bear arms, which was the argument, of course, that Elizabeth Proligar, the Solicitor General of the United States for Joe Biden, who would have been the next U.S. Supreme Court Justice had Joe Biden got another 4 years via Kamala Harris. I'm happy to report that's not going to be happening. And that's good news for the Second Amendment, obviously. So I digress, but the point is that Solicitor General Proligar argued that if we can show that you're irresponsible alone, we can take away your right to keep and bear arms. And the Supreme Court in that opinion in Rahimi by Chief Justice John Roberts says that is a no-go zone. Being irresponsible alone is not a basis for disarmament, consistently with the Second Amendment. Very good news. So the bottom line is Kendall Brown's indictment for possessing a firearm while under indictment for a crime that ultimately fell away failed. And I'm happy to report that the Second Amendment prevailed. And again, as I point out, not all cases are precedential. Many are just important to the people involved. And here's an example where all the precedents that we've talked about, all the precedents that were set in these various cases across the country are now bearing fruit by really making it harder and harder and harder for the government to come up with excuses to take away our rights. And again, this would be an example where if the government got its way in Ohio, they could have disarmed Mr. Brown for life by claiming that, hey, yeah, we couldn't convict you of an underlying felony, but we're going to convict you of a felony for possessing a firearm while under indictment for a felony we could never prove occurred, and now we're going to take away your gun rights for life. You see this game? Well, I'm happy to report this Ohio court and this opinion by Judge Pierre Bergeron shut down this game. Big win for the Second Amendment. This is a very well-written decision. We may even talk about this again in the future. I'll put a link to it down below if I can figure out how to do that in the description of this video. So there you have it, folks. Another win for the Second Amendment. Every win is another brick in the wall. Like I said, our right to keep and bear arms will be protected by brick, by brick, by brick. And every win in favor of the right to keep and bear arms, and this was a win, is another brick in that wall to protect our rights. So there you have it, folks. Hope you learned something here today at the Four Boxes Diner. Make sure you subscribe to me on X at Four Boxes Diner. We have almost 22,000 followers over there. Don't forget to share this video and like this video and subscribe. We're trying to get to 200,000 subscribers to continue to help us with the algorithm. And please follow me on Rumble as well. We're trying to grow over there as well. I know a lot of people prefer to use Rumble, so I'm now posting my videos on Rumble in addition to YouTube. And again, thanks for tuning in. I look forward to talking to all of you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.